Continuing on the same theme, in the cases involving, for example, mistakes or internally contradicting arbitration agreements, would such an issue also affect consent and also ultimately the validity of the arbitration agreement?
Absolutely. One of the early Secretary Generals of the ICC Court of Arbitration, the International Chamber of Commerce Court of Arbitration, Frederick Eisenman, wrote a famous law review article, if indeed law review articles can be famous, a famous law review article about pathological arbitration clauses. And by this, he referred to arbitration clauses that have, as you put it, mistakes or inconsistencies. There are many examples of such clauses, which I think owe their existence to the late night drafting of many arbitration clauses. It's legend that arbitration clauses are typically drafted at 11:30 p.m. in the evening just before signing. It's the last thing commercial parties and their lawyers think about, and thus they tend, it is said, to be sloppy. Experience certainly confirms that in many cases you have poorly drafted arbitration clauses, which, for example, can refer to non-existent arbitral institutions that never existed, or to institutions that used to exist but don't exist anymore, or alternatively to two different institutions without clarifying or indicating how those two institutions are to coexist or cohabit, or perhaps to both arbitral institutions and national courts. And Eisenman described all of these clauses as pathological clauses, which in his words, and I do quote him now, belonged in a museum of dark monstrosities, and that weren't even worthy of the name arbitration agreement, much less being enforced as valid arbitration clause. I take a different view. I don't see these mistakes as monstrosities, monsters to be put in some dark museum. I instead see them as patients who need to be taken care of, need to be taken care of in order that their mistakes be remedied. And I believe this is entirely possible, but also consistent with what national courts have done. National courts have looked at, for example, clauses that refer to non-existent institutions and tried to make sense out of them. Not put them in a dark museum, but tried to understand what the parties really wanted. And what courts and arbitral tribunals in these cases have usually done has been to correct misreferences. If the parties refer to the International Commission of Commerce